7 minutes past 10. Really interesting story. This could have implications for lots and lots of you listening and lots of your employers, perhaps. The Court of Appeal will make a ruling this morning on the case of a man who claims that the system of criminal records checks infringes his right to privacy. The man, known only as T, received minor cautions from Greater Manchester Police when he was 11 years old. Those cautions were revealed in criminal record checks when he later applied for a job and a university course as an adult. Lord Dyson, who is the Master of Rolls, is expected to rule that workers should not always have to disclose minor convictions to potential employers, and the judgment will have major implications on how checks are conducted in the future. I'd love to hear from you this morning if you know, if you have been, it used to be called CRB Checked. It's not that now. It's DBS. It's the Disclosure and Barring Service. But if you've been CRB checked for your current job, how was that handled? And how involved were you in that decision? 0500 909 693. Equally, if you run your own company, if you are an employer of people listening to 5 Live this morning, and you've had to conduct such checks, how do you go about them? 0500 909 693. Christopher Stacey joins us. Christopher is from Unlock, a charity that campaigns for equality for reformed offenders. Hi, Chris.
Good morning, Phil.
And Dave Milliken is Director of Family Services for Home Start UK, which supports families with young children. Hi, Dave.
Good morning, Phil.
Chris, let's start with you first of all, if I can. Obviously, in this case, the man received a caution when he was 11 and then had to disclose it later on in his adult life. What kind of things should you have to disclose? I mean, if you've received a caution, should you have to disclose that as an adult?
Well, I think with the gentleman concerned, his police warning that he received, which is a sort of children's version of a caution, was a theft for 2 bicycles when he was 11. Now he's in his 20s. I think it's fair to say that is likely to be classed as old and/or minor, and not particularly relevant to recruitment decisions, which is where this information really hits home to people. There's over 9 million people with this kind of information, convictions and cautions on their records. It affects a lot of people, and what we're talking of here is not so much the retention of the information by the police for their policing purposes, but more the disclosure of that to employers. And when this information is disclosed on the face of a CRB or a DBS check, it doesn't provide any context or any information. It drives a lot of people out of even applying for jobs, because they immediately see CRB check and they think, well, I haven't got a chance of getting that. And with 9 million people, that's a lot of people that employers are unwillingly sort of ruling out, unnecessarily.
Christopher, what about this phrase we use all the time in society? Oh, so-and-so's conviction is spent.
Well, yeah, that's an important point. So the Rehabilitation of Offenders Act is what defines whether something is spent, and cautions become immediately spent. But whenever a DBS check, i.e. a standard or enhanced CRB check, as they've been known, is done, then that discloses all convictions that somebody has ever received until they reach 100 years of age.
So there's no parity there, is there?
Sorry?
There's no parity there.
No, there isn't, absolutely. It's a completely disproportionate system. I think it's fair to say that, CRB checks, DBS checks have a role in recruitment, but insofar as a balanced role. The Rehabilitation of Offenders Act now is becoming increasingly eroded by the CRB regime that we've had for the last 10 years or so. A vast number of recruitment opportunities have CRB checks now, so that you can forget about the Rehabilitation of Offenders Act for those purposes, because they disclose all cautions and convictions. And we have people call us on a daily basis to our advice line from people who have cautions, convictions, minor things on their record from 30, 40, 50 years ago that, they were told at the time would never be there now. And because we've had so much of a complicated system over the years that people don't know where they stand, unfortunately, at the moment, it's very clear. All information that's held on the police national computer is disclosed to employers for standard and enhanced checks, and at the moment that is what is disproportionate, and that's what this case is looking at rectifying. So we're looking to be working with the government to try to introduce some form of filtering process for this kind of information, which is what we've tried to do over the years, but the government haven't really wanted to listen, which is why we've ended up where we are with a court case that's been brought separately to ourselves, but where it's been brought to the point where the government now need to look at this seriously and do something about it.
Well, we'll look at the ramifications for this in just a moment with you both. Obviously, the Home Office have noted the media coverage of this, but the DBS understands from the Home Office that contrary to the coverage, no judgment has yet been given. Well, obviously, we're expecting that in the next hour or so.
Yeah.
They say that when they get the judgment, we will work with the Home Office to assess how or if it will impact in its disclosure service. So that's their point of view. Dave Milliken, as Director of Family Services for Home Start UK, I would imagine you yourself have had to have your criminal record checked, haven't you?
Indeed, yes, and also I happen to be a cricket coach, and when I joined my cricket club, they wanted a disclosure as well.
So what's the idea of a criminal records check? It's ostensibly for people who are going to be working either with children or with vulnerable children or adults. Is that right?
In our case, that's the case. Yes, it's we're the country's leading family support charity, and we're currently supporting 32,000 vulnerable and sometimes complex families. And what we do is introduce volunteers into the family's own home to offer them emotional, practical support, often at a time of crisis or great difficulty.
So this chap T, who's brought this case, let's say he'd applied to work for Home Start UK and you found out he'd nicked 2 bikes when he was 11. Would that stop you employing him?
Well, we have a recruitment of ex-offenders policy, which we think allows us to have a proportionate response to convictions. It's obviously our commitment to ensure that people aren't disadvantaged by an offending background is subject to an overriding consideration about safeguarding of children and promoting the welfare of children and protecting the families. So it's a balancing act. So I know we do have some volunteers who do have convictions. What we would do is assess the particular risk that may or may not be involved. And obviously there's a number of factors, the passage of time and the seriousness of the offence being the major factors that you would take into account. It's quite difficult to come up with a system which specifies, if you're convicted of shoplifting at age 16 and you're now age 35 and you've had no convictions in the intervening period, then you would probably assess that as being not a major risk. But if you're 19 or 20, it can become quite difficult to introduce a sliding scale. But that's exactly what the Rehabilitation of Offenders Act did when it was introduced. It was
that was 1974, wasn't it?
It was indeed, yes. It preceded the whole DBS or CRB system as it then was.
Yes. Let me just interrupt you, Dave. You can get that on the phone if you need to. I'm just going to speak to Tom, who's given us a call on 0500 909 693. Should stress that Tom is not his real name. Reasons for that will become clear as we unfurl in the conversation. Hello, Tom.
Hiya.
So what happened to you?
Yeah, situation was, about 10 years ago, I was on a night out, a little bit drunk, urinated in the street, and now got stopped by a couple of police officers. At that point, we had a bit of a conversation. I said, haven't you got anything better to do with your time, which I maybe shouldn't have said at the time. At that point, I was arrested and spent a night in a cell.
Were you charged?
I was given a caution for drunk and disorderly. 10 years later, I applied for a job at a bank, and I was told that they were going to do a CRB check. I went through a period where it was quite stressful, thinking, is this still on my record? I wasn't sure whether it would be or not, and in fact it was still on the record. I had to explain the situation to the employer, who I did manage to get the job in the end, but it was a stressful week or so where it could have gone either way. And
what was said to you by the employer then?
Well, I was sent a letter prior to, so I was aware that they were going to be told during the process, during the interview process, and I spoke to the employer, who, fortunately for me, could understand the situation and could appreciate it. Was, a long time ago. It was minor, and fortunately, I got the job. But I could definitely see in a scenario where an employer would look at that and wouldn't even take the interview further, wouldn't give you a second or third interview. Let
me just ask Christopher Stacey from Unlock: is it common purpose for a bank to CRB Check employees, Christopher? I'm just trying to leaf through now.
Yeah, no, absolutely.
I'm trying to look through the Rehabilitation of Offenders Act to see which criteria bank employees would fall under.
Yeah, precisely. That was immediately my question. I mean, it's great to hear Tom has managed to get through that situation. I would question whether the bank in that particular job was exempt from the Rehabilitation of Offenders Act. It depends on the nature of the job, but there's some positions that are FSA regulated, but I doubt that applied there. So that hits at another issue with our system, which is that a lot of employers conduct ineligible checks, and what I mean by that is carry out levels of checks that they're not entitled to. And I think in Tom's case, I would have thought that position was only entitled to a basic level check, and so only have to disclose unspent information.
It was actually FSA regulated.
Right. Okay. Well, that explains it then. Okay. Sorry. That explains.
So just clear that up then. If they're FSA regulated, they're entitled to request one.
If the position itself, so it's not so much a bank, all positions in a bank, but if it's an FSA approved person role within the bank, and that discloses all information. And while it's great to hear that Tom's managed to explain that, as he said, it's a very stressful situation. And unfortunately, we get a lot of people calling us who either opt themselves out of that process as soon as they realise that that's going to happen, or end up going through that process and come out of it feeling a bit battered and bruised, and often without the job as well.
Now, the thing is, Christopher, it strikes me when we talk about this... Sorry, go on, Tom. Did you want to jump in?
Yeah, it was just a minor issue, obviously, at that time, a mistake I made.
Yeah.
And I just didn't want... It was... I think from a discretion point of view, whether it be a police force, it had nothing to do with my role going forward.
Yeah, I think that's precisely the point, which is that I think what Dave was saying about the Rehabilitation of Offenders Act, what that was trying to do was draw some kind of process that would sort of decide whether something was relevant or not. And at the moment, we don't have that for jobs that involve CRB checks, either standard or enhanced.
Now, the other thing that's interesting on this is that if this had come up as, say, a bad credit history, you can do things about that, can't you? If you discover bad credit history about yourself, you can get that expunged from your record. But you can't... Tom cannot get rid of this, can he? This will always come up when he applies for next job and his next job and his next job.
Absolutely, and that's precisely what we're looking to try to do with the government, which is introduce... It's a bit like a second-tier Rehabilitation of Offenders Act. So for the jobs that involve CRB checks, looking at a more proportionate level of information. At the moment, what the police do, and this isn't a criticism at them, this is more just what they're required to do by law, they literally dump information from their systems onto a piece of paper that gets sent to an employer. And if what we're trying to do here is protect children and vulnerable adults and support employers in making proper risk assessments in relation to information, I think the system needs to do more to support employers. And there's lots of facets in that. That's not just about filtering old and minor, because we recognise, that even some spent convictions will have to still be disclosed to employers. And so in that situation, it's about supporting employers in making proper risk-based decisions. And as Dave from Homestart said, actually in this particular case, it's unlikely that would have had an effect on this gentleman, the guy involved in this Court of Appeal case, his actual employment, because lots of employers do take these decisions and based on proper risk assessments. But what we're talking of in this case is very old and very minor. And in those situations, I think we need to support employers by, taking that decision and supporting them, so that we're not just dumping information to them and expecting them to deal with it.
Thanks also to Christopher Stacey from Unlock.